This is Tim Valley of Polaro Mazza. Welcome to Navigating the FAR and DFARS, the most confusing and little known clauses. Appreciate you all joining us today. As you can probably surmise from the title of today's presentation, we're going to be talking about some government contracts regulations. We are, of course, not going to be discussing all of the FAR. It's a vast regulatory body. It's constantly changing. Including some of the regulations we're discussing today. The goal today is to provide some general guidance and information about some clauses that Christine and I often encounter in our practice on a broad array of topics. So we hope to get you a little information, provide some anecdotes, and just an overview of some trickier parts of the FAR. So we'll get started. First, however, I'd like to give you a little bit more information about ourselves. I have been with Polaro Mazza for over 4 years now in the government contracts practice group. And part of that, though, is I get to work in all the firm's practice areas, whether it's litigation or corporate, sometimes labor and employment. But government contracts, as I'm sure you all know, isn't just government contracts. It hits a lot or many areas of the law. So it's exciting. You get to learn new stuff all the time, and that's where I help the firm out. I do a lot of mergers and acquisitions, protests, innovations, and just general regulatory compliance. So I get to dip my toes into a number of areas. And I will let Christine, who's new to the firm, talk about some of her practice with the firm.
Hi, everyone. My name is Christine Fries, and as Tim mentioned, I've only been at the firm for just under a year. I also have the opportunity to work on a variety of different matters, like Tim, doing mergers and acquisitions, protests, and general compliance. So I'm happy to be here and shed some light on some of the knowledge that I have learned at my time at Polaro Mazza.
So a little bit more about the firm, if you're not familiar with us. We are a full-service business law firm. You may have heard of us as a government contracts boutique firm. That is certainly true. However, we also have practice groups that cover a vast array of issues, from audits and investigations to private equity. As I mentioned, mergers and acquisitions, cybersecurity. We truly are a full service law firm, and we've grown quite a bit in my 4 years here. So we have dedicated attorneys in litigation, corporate, GovCon, labor and employment. And many of our attorneys are used to wearing multiple hats. So Christine and myself, for example, we can help you with GovCon protests. We can help you with a merger and acquisition. I can then help you through litigation when there's a dispute between parties. And if we don't know the answer, someone in the firm does. So we typically know just who to hand it off to. But more importantly, as a small firm, we provide large firm results, but on a small firm budget, which pretty much means smaller bills, which our clients tend to like, but with the results that they should expect from their lawyers. So today we're gonna cover numerous areas, as I mentioned, mergers and acquisitions, which entails the sale of either assets or ownership interests of a company, which implicates numerous regulatory issues for government contractors. Then we'll talk about allowable and unallowable costs when you're invoicing the government. Data rights, which is a very hot topic area these days, involving intellectual property and licensing to the US government. Then we'll go into contractor team arrangements and subcontractor sales to the government. SBA's mentor protege program, both 8A and all small program. Post-employment restrictions for government employees that are entering the private market, the non-manufacturer rule, which applies to small business supply contracts, IDIQ ordering procedures, so what IDIQs are, how it affects protests, and different procurement regulations that apply to solicitations under IDIQs. When things go wrong, for example, a rogue employee commits a crime or submits a false claim to the government, we'll then talk about mandatory disclosures to inspector generals. From there, we'll go into employee compensation reporting and another hot topic area, performance of work requirements. And then we'll conclude with organizational conflicts of interest, also known as OCIs. And then we'll finish it out with debriefing requirements, which concern GAO protests primarily, and the rights you have after awards for procurements are announced. So we have a lot to cover, so we'll just launch right into it and start with mergers and acquisitions. So before I even go into the FAR clause about post-award small business program re-representation, there are, in a nutshell, two types of mergers and acquisitions for government contractors. There's sale of ownership and there are asset deals. So the reason that's important is one triggers different types of requirements. So when you're changing the ownership of a company, all the assets of that company generally stay with the company, as opposed to an asset purchase deal where the ownership of the company stays the same, but another company is buying all the assets typically associated with the government contracts, or they're buying a division of the company, for example, that holds numerous government contracts. And the reason that's important is because if the ownership is staying the same and the assets aren't moving, then there's no requirement to go through a novation, which essentially means asking the government to recognize an assignment of government contracts. Under federal law, unlike in the commercial space, you cannot assign or novate a government contract from one government contractor to another. If you sell the assets associated with the contract and if you assign the contract itself, you must get permission from the US government to do so. It can take 6 years to a month to get that approval, and it's a very large consideration when a government contractor is deciding whether to even go down a merger and acquisition path. It also helps form the strategy in the merger or acquisition. So for example, do you want to do an ownership deal or do you want to do an asset purchase deal? Regardless of the type of acquisition or merger you're performing, this FAR clause, the post-award small business program re-representation clause, it's in many, many government contracts, especially small business contracts, which are what it primarily affects. And following closing of a merger or acquisition, within 30 days after the execution of a novation agreement or a merger or acquisition, the contractor has to recertify as to its small business size. This is important because if you have small business contracts and you are being bought out by a large business, you will no longer qualify as a small business under this contract. So for example, years ago we had an example where a government agency had planned a long time for procurement. They finally got a small business contractor. That small business contractor did not tell the agency they were undergoing a sale of the company to a large business. So, within months after contract award, they told the government agency, we're no longer small, we've been bought by a large business. That company had to re-represent its size, and then the agency was no longer able to take small business credit for its own statutory obligations, and they ended up terminating that contract. The government was furious. So this clause is important for mergers and acquisitions and for planning purposes, because if you are no longer small, after a merger and acquisition occurs and you re-represent to the government, there is a chance that your contract has off-ramp procedures or termination for convenience procedures, or that your changed size status could trigger a reaction from the government that could result in termination of your contract. So this is a critical regulation to keep in mind when you're selling a government contractor or selling assets, as it could result in downstream results that could end up resulting in loss of the contract. Otherwise, for the third bullet here, long-term contracts, these are typically 5 to 20-year contracts with multiple option periods. You have to re-represent your size within 60 to 120 days prior to the end of the 5th year of the contract. Or as I mentioned, with options, the government can also ask you to recertify. But again, as I mentioned previously, if you re-represent and you're no longer small, the government cannot take credit, small business credit anymore, but they can still allow you to perform under the contract. So it's something to keep in mind, and you definitely want to raise it with the government in most cases when you're considering a merger or acquisition. Relatedly, and you'll note that this is a CFR regulation. This is an SBA regulation, which is similar to the FAR clause, but as with many SBA regulations or agency regulations, they're typically updated more frequently than the FAR, and they can sometimes be at odds with one another. So this is an example of an SBA regulation that doesn't quite align with the FAR clause, but government contractors are subject to both clauses, and they're subject to the terms of their contract. So it is complicated to be a government contractor sometimes, because you have a regulatory body from an agency, you have a regulatory body from the FAR Council, and you have your contract's terms which you have to comply with. This clause here essentially mirrors the other FAR clause, this one, FAR 52.219-28, but with some slight differences as to when recertification is required. So if you go to paragraph 2I, recertification is required when a concern acquires or is acquired by another concern. Interestingly, from both the acquired concern and the acquiring concern, if each has been awarded a contract as a small business, this is where you'd want to plan your merger and acquisition accordingly for both the buyer and the seller. And it's something to keep in mind that's a little different from the FAR clause. And also when a proposal is pending. So if a merger, sale, or acquisition occurs after but prior to award, the offeror must recertify its size to the contracting officer prior to award. There are also new regulations about how long that is extended out. I believe it's 180 days. So as you can tell from the conversation about these slides, is there are numerous requirements from different bodies that you should be aware of when you're going through a merger and acquisition. Part of our job, of course, is to help lessen the blow from some of these recertification requirements. There are loopholes that you can go through under these requirements that our firm, we work to structure deals in ways to avoid a recertification requirement. They're untested to date, but you can move forward if you're willing to accept some risk to avoid recertification, but there are ways to get around this. The other important clause to keep in mind, or these are two more SBA regulations, are the former affiliate rule. So affiliation generally means if you are affiliated with another company, for example, if company A owns 51% of company B, those two companies are de facto affiliated, meaning you aggregate their revenues or employees to determine their size for a particular NAICS code, North American Industry Classification System code. However, if company A were to sell all of its ownership interest to company B, so that company B now owned 100% of itself, company A would then qualify as a former affiliate. Once that affiliation has ceased under SBA's regulations, you no longer count revenues and employees. So the size of company B would just be solely company B's revenues and employees, which would shrink its size. And you did that retroactively for the full period of measurement. You probably noticed I skipped over, can a division count? In the past, companies were able to, put their books and their contracts in their company in a way, in a division, that they were able to segregate out costs. And companies were selling divisions which had certain revenues or employees with them to other companies. And that was a means to, if you were bumping up against a NAICS code, perhaps with a $15 million size standard, that was a way to get your size standard to stay under that $15 million NAICS code. Now, companies started doing this, SBA caught on to it, and SBA closed this loophole in the rules. There were a few instances where SBA approved these division sales and found that you did not have to count the revenues of a sole division towards your company, but SBA caught wind of it, and they issued a new regulation completely closing this former affiliate division loophole. So that is no longer possible as a way to stay under your applicable NAICS code. So how do you address this? One way is to simply, instead of creating divisions, is you create subsidiaries. Subsidiaries are distinct legal entities that can be sold and can count as former affiliates. So company A and company B, they don't have to be completely separate companies. Company A could just be the parent company of company B and own 100% of it. But if company A wants to keep its size down, it can sell company B, which could ostensibly exist for a certain NAICS code or for a certain type of contracts. It could create companies B, C, D, E, all devoted to different NAICS codes. And it could eventually sell those subsidiaries out. So a loophole still does exist. It's just not going to be through divisions. But of course, creating separate entities, it requires a little bit more work on the front end. And you have to be careful with what type of small business it is. So for example, that method would not work for 8A companies, WSBs, but could work for some other companies, potentially hub zones, or just general small businesses. So definitely something to keep in mind as you consider mergers and acquisitions, because for government contractors, as you can see, it's not as simple as just selling off your assets or your ownership. There are reporting requirements to the government and implications that could result in the termination of government contracts. So it's important to structure your companies appropriately, and when considering a merger or acquisition, take stock of the terms in your contract and any regulations that might apply, which is especially important if you're a small business, given the re-representation requirements. So with that, I am going to turn it over to Christine to discuss allowable costs.
Okay, hi everyone. So we are going to talk about allowable costs next. FAR 31.201-2 gives us direction to determine whether costs are allowable or not. There are 4 things we're going to look at: the reasonableness, allocable to the contract, whether cost accounting standards and generally accepted accounting principles were used, and then the terms of the contract. Also, right now we're seeing a huge uptake in claims and requests for equitable adjustments, or REAs. So we're going to talk about those in this context as well. So first, we're going to determine reasonableness. We have to look at 4 things in determining reasonableness: whether it is the type of cost generally recognized as ordinary and necessary for the conduct of the contractor's business performance, the restraints or requirements imposed by such factors as generally accepted and sound business practices. So if there are laws or regulations or specific to your contract, something that's unallowable, then those may not be reasonable. Further, the action that is prudent, a prudent business person considering responsibilities to the owners of businesses, employees, customers, the government, and the public at large would take under the circumstances. So think about it like a reasonably prudent business person. Would they make that decision the same way you did? And fourth, any significant deviations from the established practices of the contractor that may be unjustifiably increase the contract costs. So what is important here is reasonableness is not presumed. It's up to you as the contractor to illustrate that the cost you are trying to recover is reasonable. So with that in mind, it's really, really important to make sure that you're documenting not only the costs with general accounting practices and staying in line with that, but also if you're making decisions, you should be documenting those decisions in terms of costs. Let's say you want to pay for something that's a little more expensive, but you have a reason for it. Make sure you're documenting that so that if there is an issue and you do want to try to recover costs, you can say, oh, here was my rationale for that decision. Next, the next point is determining allocability. So a cost is allocable if it is assignable or chargeable to one or more cost objectives of the basis of relative benefits received or other equitable relationship. So you need to look if it's a cost that's being incurred specifically for the contract, if it benefits both the contract and other work and can be distributed to them in reasonable proportion. So let's say you buy something in bulk, but you're only using part of it for the contract. You need to be able to show which part you're using. Is it necessary to the overall operation of the business? Although a direct relationship to any particular cost objective cannot be shown. Again, this is also going to help if you document what you're using certain items for, or professions or labor. So again, just make sure you're documenting everything. So there are some unallowable costs under FAR 31.201-6. This list is just an example. There are obviously other options, and that kind of brings us into talking about claims versus REAs. So a request for equitable adjustment is different than a claim because an REA needs to be submitted during performance of the contract or closeout, but not after the contract. And this is really important because there could be a change to your contract, and there are certain instances where you can recover costs. And when determining what costs are allowable under an REA, something like attorney's fees or administrative fees are actually recoverable under an REA. What the difference is an REA is less formal and it doesn't require the contracting officer to make a decision. It's more of just a general goodwill. Let's talk about what is going on and let's see if we can come to a solution before a claim gets filed. A claim is something that's more formal and it's filed under the Contract Disputes Act. Here, it's important to note that prep fees are not recoverable. So attorney's fees, admin fees, anytime you take to build the reasons behind your claim, they're not going to be recoverable under the claim phase, but they are under the REA phase. And if you have questions about that, it's really important to reach out to an attorney, us, because we can help you prepare an REA before it gets to the claim phase, and we can try and recover our attorney's fees as well under that. Or it's
And
something we can, oh, go ahead.
oh, sorry, Christine.
Or it's
So
something we can, oh, go ahead, Tim.
sorry. To Christine's point, the REA is essentially completely recoverable in terms of attorney's fees. And as a practical matter, the substantive difference between an REA and a claim generally is a demand for payment in a set amount of time, and depending on the amount, a certification. So when we draft REAs, which you can recover attorney's fees for and consultant fees, if they deny it, we draft it in a way that it's very easy to convert to a claim. So it's often highly recommended to get an attorney involved with the REA process, because they can draft it and gear it up for a claim if the government's not willing to essentially pay out the cost, which will then ease your way into, you know, an appeal or litigation down the road.
Exactly. This is just a way for you, REAs versus claims is a way for you to kind of get ahead of the claim or possible litigation and try to solve the problem beforehand and receive additional allowable costs under the FAR. Also, another example is, you know, client engagement is generally an allowable cost. So you go to a conference for client engagement, and then you spend money on advertising, which is typically an unallowable cost. You need to make sure you're documenting what is being used for what, so that you are able to recover the most when attempting to recover costs. So again, just make sure you're documenting everything beyond just accounting principles. Also document the decisions you're making and why you're making those decisions in order to be able to recover additional costs if there's an issue that does come up. Tim is next going to talk about data rights.
Okay, so as I mentioned earlier, this is a hot topic area. It's data rights. And before I launch into some of the specifics with these FAR clauses, I wanted to just give a little bit of background on the development of intellectual property in the United States. The real turning point in the United States was the Bayh-Dole Act. I can't recall, I think it was passed either in the late 80s or 90s, but it essentially changed the way the government approached intellectual property and data rights. Prior to the Bayh-Dole Act, the government essentially kept ownership over what it bought. And they found that this stifled the growth of new technology. So after the Bayh-Dole Act, the government very rarely now takes ownership of what it pays to develop. Instead, it takes certain categories of data rights in what it pays for, or pays to have a contractor provide to the government. So the main takeaway there is that generally, in the vast amount of times when a government contractor is producing data rights under a government contract, the government contractor maintains ownership over that intellectual property. The government can buy it, but generally the government does not. They take certain rights, whether it's unlimited rights, limited rights, restricted rights, which we'll talk about in a little while, but the government contractor keeps ownership. However, depending on the rights that the government asserts, or if the government contractor potentially does something incorrectly with its markings, the government could take unlimited rights, which, even though it doesn't have, quote, ownership, it essentially gets to do whatever it wants with the data or with the intellectual property. So even though it doesn't take ownership, it is critical to get it right when you're asserting varying types of data rights to what the government can take in that type of IP. So there's also, to further complicate this, different FAR clauses depending on which part of the government you're contracting with. So a civilian agency, meaning non-DoD, so this would be, the VA or GSA, any of those civilian agencies, they would use FAR 52.227-14, rights and data general. And then there are certain categories of rights that the government can assert in the data. So as a default, if the government is paying for the production of data or the creation of a program or technical data or what have you, it will assert unlimited rights, meaning you keep ownership of it, you can commercialize it, but the government gets to do what it wants to do with it. Conversely, if you are bringing data to the government that you created with your own dime, you will tell the government it can take limited rights or restricted rights, meaning that the government can use it, but it's subject to limitations, meaning it cannot go out and give your program to another contractor to reproduce, or just send it throughout the government, or just have unlimited copies of it. It's limited. The key, though, is that this FAR clause includes specific license language that you have to put either in a license or on the data itself, and market and assert those rights. If you do not do that, you can lose the ability to restrict the government's rights in that data. So if you get this wrong, the government could still take unlimited rights, even though it's your data that you brought to the government and the government didn't pay for. So it is critical, especially if you're providing another company's data, if you're the prime and you're providing a product of a subcontractor, that can open you up to a host of issues if you're not putting the right language in the license. Luckily, there is a 6-month grace period. So if you discover that you missed it, which does happen, mistakes do occur. The FAR is somewhat forgiving in that respect, in that you can cure it. But the government, if you go beyond those 6 months, or if you get something wrong, the government could take unlimited rights. So it's very careful to get these things correctly. So like I said, there are different types of FAR clauses that apply, whether you're in the civilian or the defense arenas. So in the defense contract arena, they have far more sophisticated FAR provisions, and they're broken down by the type of data. So the first one mentioned here, 52.227-7013, deals with technical data and non-commercial items. The second one, 227-7014, concerns rights in non-commercial computer software and non-commercial computer software documentation. So the key takeaway there is figure out what type of data it is that's being procured or that you're bringing to the table, because that will dictate which FAR clause applies. And then each one has its own procedures for marking the data, and then the types of rights that will apply for the parties. So rights granted to the government, these are the government's rights that it gets to take in certain scenarios. So unlimited rights, as it should imply, is the government paid for it. The government paid for you to produce this non-commercial computer software. The government will assert almost always unlimited rights in that software, meaning it gets to do as it pleases with what it paid for and bought from you. On the other hand, if you are bringing in something partially developed and the government is paying for part of it, but not all of it, Perhaps you've negotiated government purpose rights, which gives the government the right to use it in certain scenarios, but not necessarily to have other contractors use it, or to use it throughout the government, or to have it, or to procure it from other government contractors. That's one. And then limited rights is where, and this again, it's restricted rights if it's non-commercial computer software as opposed to limited rights. So again, you want to figure out what type of data it is to figure out which rights would apply. Limited rights would be, it's your data, you created it, and you're bringing it to the government for it to use in a limited capacity. And in this instance, you would want to delineate exactly the limitation in a license, in an end user license agreement, and by using the correct markings when you are submitting your proposal. And as I mentioned, just like with civilian contracts, this can get hairy if you do not do it correctly and you're providing a subcontractor's data and they're expecting you to do it correctly if you're the prime. So again, it's really important, figure out the type of data it is, and then figure out the rights that should be delineated between the parties. It is something that people get wrong, and they'll put thousands and thousands of dollars and man hours into a product and then accidentally give the government far more rights than it's entitled to. I see it happen all the time. And you would think, well, the government can't just take it, but if you don't assert your rights, the government can, and that's in the FAR clauses. So it's important often to have your attorneys look over these licenses and these contracts to make sure that it aligns with what's going on the ground with the funding for the development of that data. So one follow-up question, of course, is, when are these restrictions determined? How do you determine sometimes if it's something you're bringing to the table, if it's something partially brought to the table, or is it a brand new product that the government's paying for? And at what point do those rights attach? So, if you're building something, is it just from the beginning? No. Under the FAR, allowable restrictions are determined at the time of development, and that is a term of art defined in the FAR. I've put it on the slide for you, but essentially it means that the item, component, or process exists and is workable. And depending on the data that you're working with, there could be different standards for when it is, quote, developed. So it's important to keep this in mind to know when these rights are going to attach. So the other thing to keep in mind is that data and development and the rights that attach that data, you want to do it at the lowest practicable level. And by that, I mean you can mark data even at the code level. If you're bringing new code, you can insert legends and markers into that code that you're creating for the government, or that you're bringing to the government. You just want to make sure that it's done at the lowest level. So, like I said, developed, it's going to depend on the type of data you're working with. So for example, it could be a computer program, it could be a computer software, which is different under the FAR, or it could be computer software documentation. Under any of these scenarios, it's gonna vary with what kind of rights attach and when it's developed. So another type of data, another FAR clause beyond 13 and 14, which I mentioned earlier, is the commercial realm and technical data. There are certain things that when the government procures a commercial item, they're gonna get unrestricted rights in it. And they fall into general three categories: form, fit, and function data, any data that's necessary for operation, maintenance, installation, or training, and propose segregation and reintegration data. So if it's necessary for the segregation of an item or process from, or the reintegration of that item or process with other items or processes. So that's slightly more detailed than form, fit, and function data. But for this type of data, it's important to understand that the government is going to get unrestricted rights in it. However, it still doesn't get to use that information to, for example, manufacture additional quantities of commercial items. But if it is a commercial item, they are going to get unrestricted rights in these types of data. Otherwise, you're probably going to just have a license or an end user license agreement that the government accepts with your proposal, and that's the data they're going to get with that specific commercial item. You know, for example, you know, if you're providing, you know, a Microsoft Word or another Microsoft program, which is considered a commercial item, you know, they don't take ownership of that. They don't get all the rights that Microsoft has essentially licensed to you as a reseller. The government's going to get limited rights in that, except for these categories. So with that, I'm going to turn it over to Christine to talk about contractor team arrangements.
Okay, so contractor team arrangements are actually another hot topic because they're being used a lot in procurements, especially the best-in-class vehicles, and it was used in the draft of the CIO-SP4 contract that is supposed to come out this week. So this is another kind of hot topic. What it is a contractor team arrangement is one of two following scenarios. First is two or more companies form a partnership or joint venture, or second, a potential prime contractor agrees with one or more other companies and they form like a prime sub relationship. So subsection 2 is easy. It's a traditional prime sub relationship. However, subsection 1 is a little more complicated because of the word partnership. Partnership is really not defined. Both SBA and GSA are kind of in a standoff. Neither have made rules about them. So it is a little problematic because you could potentially assume you're forming a partnership, but since there's no real direction, what does that mean? So our best advice is to use, instead of reading partnership, it should be just joint venture, and you should follow under those performance of work requirements. Since partnership isn't really defined, the first section really is going to have to be joint venture, and you, as a small business, as a large business, this matters less, but as a small business, the safest option is really to just be a joint venture and follow those performance of work requirements. And you should ask the questions below. Do CTAs formed for the purpose of pursuing a GSA scheduled task order count under subsection 1? Are JVs and partnerships the preferred method of forming a CTA under subsection 1? So ask yourself those questions. What does it really mean? But really, since we don't know that much about it, it is important just to talk about it and think about it more as a joint venture. Next, we have restrictions on subcontractor sales to the government. So when are non-compete provisions contained in teaming agreements enforceable, and how do you craft your subcontracts so your teaming partners cannot directly compete against you for the same work? So this is going to be very fact specific, and it's really important to think about which position you're in. A non-compete can help protect your company, but it also can put you at risk if not done properly. And it needs to remain very narrowly tailored to a legitimate business interest, which is kind of hard to talk about generally because there are so many different circumstances that this could come up. But So you really should reach out to us or an attorney to craft the language that works for your contract in order to make sure that the non-compete is actually enforceable. And this will help, protect you, but also create something that is ideally workable. So next we have SBA's Mentor Protege program. So this is a small business administration's program. So this is available to all small businesses, and it really is just for small businesses can form a joint venture, only unpopulated, with a large business mentor, or obtain capital from the mentor in exchange for a 40% interest in the protege. So the protege would be the small business. An unpopulated joint venture, most people probably know this, but what it is it's a joint venture. It doesn't have employees. You kind of use it just as a vehicle for your program, and then each company, the mentor, the large business, and the protege, the small business, contain and keep their employees under their businesses. The JV really is just to, provide the vehicle for the program. And anyone can be a mentor. It's limited to 3 proteges, must only show that you can meet their obligations. However, there are more regulations for proteges. You must be small, under a primary NAICS code, or assistance is for a specific secondary NAICS code, must have prior experience, limited to 2 mentors, but must show that they are unrelated for unrelated NAICS codes. So the first mentor helps provide you something, but the second mentor is helping you provide something else. And
one thing to keep in mind is that there's the 8A program, 8A mentor protege program, and the all small program. So they are 2 distinct things. It is not just limited to 8A programs, which was the case in the past.
Yes, and that is an important note. And so make sure you are all small, and that's why that's available to all small businesses versus just the 8As. So keep that in mind, but all of these still apply. So you still need to make sure that whatever contract that you're performing, that you plan to get a mentor for, if you're a small business, make sure that the NAICS code, it's your job to make sure the NAICS code is correct and that you fall within that and you're getting support under that.
And when you're considering a mentor protege, it's important to build in time to get all of the necessary paperwork in place, because it can take quite a bit of time, and it's quite a process. So, don't just plan on pulling a joint venture from SBA's website and going from there. You're gonna want attorneys involved. We have pretty streamlined processes at the firm to get these things in place quickly, to create a new joint venture entity, to get it registered in SAM. But if you want to move forward on a procurement, plan ahead, months and ahead, and really start thinking through what each member of the JV is going to be doing. For example, who's going to provide what facilities and equipment, etc., funding. These are all really important things to start talking through early to make sure that you can qualify in time for a procurement where you want to go in as a JV with your mentor.
Okay. So next is post-employment restrictions general overview. So 18 USC section 207 prohibits certain acts by former employees, including current employees who formerly served as senior or very senior employee positions, which involve or may appear to involve the unfair use of prior government employment. So this is important if you are hiring someone that has worked in the government before in a senior position and is now coming into your company. They may have certain knowledge, so that's why these exist. None of the restrictions of 18 U.S.C. Section 207 prohibits any former employee, regardless of government rank or position, from accepting employment with any particular private or public employer. Rather, the statute prohibits a former employer from providing certain services to or on behalf of non-federal employers or other persons, whether or not done for compensation. In June 2008, the Office of Government Ethics issued a final rule providing guidance concerning the post-employment restrictions for employees terminating service in the executive branch or an independent agency. So the final rule can be found at those sites, but it does describe the government ethics rules for moving from the government to a private employer or providing advice. So some more restrictions, 5 CFR section 2641.201 contains permanent and temporary restrictions on former employees' representations made to the U.S. or to the former agency. And it defines employee as an officer and employee of the executive branch or independent agency that is not part of the legislative or judicial branches. Something else to keep in mind here is if you are a business competing in a procurement and you notice, you check LinkedIn a lot, or you notice somebody that had worked for the government now working for a company, you should flag that and keep that in mind because it could be a potential protest ground. So this section is important to remember. And if you see anything that could be surprising, or you snoop around someone's LinkedIn and see that they worked for a certain agency or executive branch position and now they work for a contractor that's bidding on the contract, you should make a mental note of that and see, is it potentially a protest ground? Is there something wrong? So there's a permanent restriction. Oh, sorry, go ahead, Tim.
As a practical matter, for government contractors, a lot of this is geared, you're probably thinking, well, this doesn't affect us. This is for government employees coming into the private sector, but it's important for government contractors because they need to be aware or cognizant of these restrictions when making hiring decisions and when putting forth key employees for a contract. So if they're barred from performing with that agency, but you just hired them, as Christine was just mentioning, that could be a way to get that to be kicked out of the procurement. So it's critical to be aware of these rules and keep them in mind as you're making hiring decisions. Sorry, Christine, go ahead.
No, it's okay. So the permanent restriction, no former employee shall knowingly, with the intent to influence, make any communication to or appearance before an employee of the United States on behalf of any other person in connection with a particular matter involving a specific party or parties in which he participated personally and substantially as an employee, and in which the United States is a party or has a direct or substantial interest. So as Tim was saying, you need to keep this in mind when hiring or when contracting or filing a bid for a contract, because you need to make sure that someone couldn't have the appearance of knowing something within their previous position that could affect you as a contractor or open up the appearance of for a potential protest ground. There are temporary restrictions. So there are no permanent restrictions as previously stated, but there are some temporary restrictions that you should keep in mind when hiring. So for 2 years after government service terminates, no former employee shall knowingly, with the intent to influence, make any communication to or appearance before an employee of the United States on behalf of any other person in connection with a particular matter involving a specific party or parties, which such person knows or reasonably should know was actually pending under his official responsibility within the 1-year period prior to the termination. So keep that in mind, as well as for 1 year after service in a senior position, no former senior employee may knowingly, with the intent to influence, make any communication to before an employee of an agency in which he served in any capacity within the 1-year period prior to his termination from a senior position. If that communication or appearance is made on behalf of any other person in connection with any matter on which the former senior employee seeks official action by an employee or such agency. And there are other temporary restrictions that concern treaties, foreign entities, participants in the information technology exchange program that you have to keep in mind, but the big ones are here. So really just make sure that you know of these and are making the correct choices when hiring or having a person communicate with the government. There are restrictions imposed by the FAR. Any person who is a present or former official of the United States, or a person who is acting or has acted for or on behalf of, or who is advising or has advised the United States with respect to a federal agency procurement, and by virtue of that office, employment, or relationship, has or had access to contractor or bid proposal information, so this is really key, or source selection information, cannot knowingly disclose contractor bid or proposal information or source selection information before the award of a federal agency procurement contract to which the information relates. So again, it's just really important that if you're hiring someone or thinking about hiring someone, that what they did in the past, that they may have knowledge or may have not have knowledge, whatever it is, if it is related to the source selection or procurement information, it needs to be not disclosed. And any person who is a present or formal official of the United States, by virtue of their office or employment, has access to contractor, bid, or proposal information or source selection information, knowingly obtain contractor or bid proposal information or source selection information before the award of the federal agency procurement in which the contract relates. FAR 3.014-3 also restricts a former official from a federal agency from accepting compensation from a contractor in certain circumstances. So again, this is really detailed, and if you have more questions, you can go look at the FAR provision, but the big level picture, which could affect you as a contractor, is that any information obtained from their position that could affect, procurement or bid selection or any of that needs to remain within that person and not be disclosed to the company, giving them an unfair advantage. So Tim's going to go ahead and talk about the non-manufacturer rule.
So first, I think we'll take, given that we're halfway through, a 5-minute break. So we'll return here at approximately 1:36. That way everyone can kind of, move around, take a nice yawn, and do what they got to do. But we will see everyone back at 1:36. Okay, hey everyone. Can you all hear me? Says my microphone's working. So I'm gonna get started again on the non-manufacturer rule. This is a tricky little rule that applies to small business supply contracts, meaning the contract itself has a supply NAICS code. This would not apply if it's a services contract. So again, make sure you're keeping an eye on the NAICS code for the contract. And the non-manufacturer rule itself breaks down into 4 elements. Now, to begin, if you are a small business on a supply contract, then you typically have to be the manufacturer or producer of that end item. So, you know, widgets, piano keys, gears, whatever it is the government's procuring. Or you can be the non-manufacturer, which is defined in the SBA's regulations. And you can still be a small business non-manufacturer, even if you're not the manufacturer. But there are 4 basic requirements to qualify as a non-manufacturer, and they are as follows. So your business can qualify as a small business concern for a requirement to provide manufactured products or other supply items as a non-manufacturer if it, 1, does not exceed 500 employees, or 150 employees for the information technology value added reseller exception, which is specific to NAICS code 541519. That's also known as ITFAR. So can't exceed 500 employees or 150 for ITFAR. That's 1. 2, is primarily engaged in the retail or wholesale trade and normally sells the type of item being supplied. So this essentially means you have to be in this line of business. You can't just hop in all of a sudden and just be primarily engaged in something. But there is OHA case law, Office of Hearings and Appeals, that details what each factor means, including the second one. And then factor 3, you have to take ownership or possession of the items with the company's personnel, equipment, or facilities in a manner consistent with industry practice. So that is going to be fact intensive and depend on the items being procured and then given to the government. But you do have to take ownership or possession consistent with industry practice. And finally, and this is a big one, you have to supply the end item of a small business manufacturer, processor, or producer made in the United States. Or you have to obtain a waiver of that requirement from the SBA. So it's critical that you're not just providing a manufactured item, it has to be from a small business in the United States, or you can get a waiver from the SBA. So that's all 4, you have to meet all 4 of those elements to qualify as a non-manufacturer. There are 2 types of waivers, essentially class waivers, which exist because there just simply are no small businesses that exist that manufacture that item, or just individual waivers which you submit to SBA. We have helped out with both types of waivers. So if you need one, you know, feel free to reach out and we can try to get one. Now, that is just that applies to a straightforward procurement where there's just one item, you just have to be the non-manufacturer. But there are also, of course, much more complicated procurements. For example, multiple item procurements. Under multiple item procurements, if 50% or more of the estimated contract value is composed of items manufactured by small businesses, then you don't need to get a waiver. So if the other 49, so the other 49 can come from large businesses. So this is kind of a way to ease the burden on the small business requirement. But it's also really important to keep in mind that if you get a waiver from SBA, or if there's a class waiver in place, it still does not exempt you from other requirements, laws and regulations and FAR provisions, such as the Buy American Act and the Trade Agreements Act, which could apply and still require you to provide a certification or some type of proof that you are supplying either a US made product or an approved product under applicable regs. So this, like I said at the beginning, is a complicated rule. It's multifaceted, and it's not the end of the analysis when it comes to supplying items to the US government. So that's the non-manufacturer rule in a nutshell. Next, we are going to go on to the IDIQ ordering procedures. IDIQ, as I'm sure you all know, stands for indefinite delivery, indefinite quantity. These are used to acquire supplies or services when the government doesn't have the exact time or exact quantities, or it's going to have varying quantities over a series of years, and they're not known when they're awarding the contract. So basically, you see a lot of these large contract IDIQ vehicles where multiple contractors are receiving the awards, and then there are task orders that they solicit from all the awardees as needs arise, whether it's services or supplies. There are 3 different types of IDIQ contracts: definite quantity, requirements, and indefinite quantity. These are also known as delivery order or task order contracts. So what's tricky about this? Well, there's a number of things that go into IDIQ contracts because different FAR parts apply depending on where you are in the procurement process. So the initial IDIQ contract would typically be awarded under FAR Part 15, which are negotiated procurements. And then the orders, task orders, delivery orders, what have you, issued under that IDIQ would fall generally under FAR Part 16, which is the part of the FAR dealing with task orders. Why is that important? Well, it's important for, most practically, depending on the value of the task order, you might not be able to protest that procurement. A statute was passed that limits jurisdiction solely to GAO, the Government Accountability Office, for when it concerns civilian agencies. If the order does not exceed $10 million in value, you can't bring a protest, period. If it exceeds 10 million from a civilian agency, you can go to GAO. For DoD, they up that to 25 million. So if the task order is only worth 24 million and it's an Army procurement, you cannot go to GAO with that protest. GAO also is essentially the sole jurisdiction to hear protests for orders over those dollar thresholds. You cannot go to the Court of Federal Claims, except under one limited exception where the protest is on the grounds that the order increases the scope, period, or maximum value of the contract. I myself have never done one of these protests. I have not seen this before in my 4 years at the firm. I know they exist. I know they've been brought, but I imagine it would be difficult to show that a contract or a task order, unless it's blatant, increases the scope, period, or maximum value of the contract, especially when you get IDIQs that have $5 billion ceilings and stuff like that. So when it comes to task orders, if you lose a procurement, typically my first question is, no matter what, when a client comes, is it a contract or is it a task order? If it's a task order, how much is it? Because I'm going to tell you, right off the bat whether you can even protest it. So that's one critical factor when you're dealing with task orders under IDIQs. So next, how does the government place orders under an IDIQ? And what do they have to do when they're doing it? So like I said, orders under IDIQs are governed by FAR Part 16. There are multiple parts. One of the main parts or regulations that we'll talk about today is FAR 16.505, which lists out all the requirements that the government has to comply with when it issues a solicitation for a task or delivery order. But generally, they have to describe the services to be performed or to be ordered, so that when they place an order, they can provide the full cost or price for that work. Related to what I was saying earlier about protests, the orders have to be within the scope of the contract, issued within the period of performance. The order can go beyond the period of performance in limited circumstances, but it just has to be issued within that period of performance, and be within the maximum value of the contract, which frankly, I think would be difficult to exceed unless the contract just has a lower maximum value. But it also sets competition requirements. So like I was saying earlier, this is under FAR Part 15 requirement. Generally, it's full and open competition. Everyone gets to submit a bid, and that's different when you're under an IDIQ contract, because only the awardees under that IDIQ contract, assuming that there are more than one, get to submit bids. They're the ones that are going to receive the solicitation or the RFQ, request for quotations. And then the FAR delineates, depending on what type of order it is, what has to occur. So under the first sub-bullet under the second section here, if it's for services, the government has to use performance-based acquisition methods, must to the maximum extent practicable. Again, the IDIQ itself was most likely based on competitive competition, so most of those elements are satisfied, but then there are their own unique competition requirements for each task order. That said, if the order is coming down from the government and it's particular to one manufacturer, the contracting officer doesn't just get to buy it from that manufacturer. They have to justify restricting it to an item peculiar to one manufacturer. So a brand name, a product, or a feature of a product. They have to justify that. Otherwise, it'd be difficult under a task order, but you could advocate that they're not doing the correct justification and approval for essentially what's a sole source or a brand name task order. So even though there are restrictions on protest, it's important to keep these things in mind so that you can keep the government accountable and make sure it's complying with these procedures. So to continue with these competition requirements under FAR Part 16.505, which again is different from FAR Part 15 and other parts of the FAR, when the government places orders under IDIQ contracts, they must contain the following information. So the date of the order, the contract number, which again, all of the terms of the contract and the IDIQ are going to flow down to the orders, which themselves could have their own provisions and FAR clauses in them. So it's important to keep in mind that you're going to have to comply with your contract and with the order. Then for supplies and services, you want the line item numbers, subline item numbers, the description of the services and supplies, quantities, unit prices, estimated costs. This all has to go into the order. And then it should also, again, tie back to the base contract. Then you'd want to go into delivery or performance schedule, place of delivery, packaging, packing, shipping, accounting and appropriation data, and then method of payment. So they need to include all this information. It'll be more scaled back than what you would see in a FAR Part 15 contract, which could be hundreds of pages. Some orders you see from the government, they're under 30 pages, sometimes under 10 pages, but it generally should include this information so that people can compete adequately under the IDIQ contract. Just continuing on with the competition requirements. And this is an area that, again, under FAR Part 15, it's full and open, but under the IDIQ, it's just the awardees. But then there are unique competition requirements under FAR Part 16 for these multiple award IDIQ contracts. What's called fair opportunity. So for multiple award contracts, the contracting officer has to provide each awardee a fair opportunity to be considered for each award, each order exceeding 3,500 or the micro purchase threshold under multiple delivery order contracts or multiple task order contracts. Then moving on from there, orders exceeding the simplified acquisition threshold shall be placed on a competitive basis, meaning, for qualified contract holders. And then for task or delivery orders in excess of 5.5 million, the requirement is to provide all awardees a fair opportunity to be considered for each order and has to include a certain amount of information. So this is where it gets closer and closer to our FAR Part 15 procurement, but it has to include a notice of the task or delivery order with a clear statement of the agency's requirements, a reasonable response period. So typically that's about 30 days. That's actually something that, when agencies edit the solicitations, and they, give you 2 days to respond, you can push back and say, no, you're supposed to give me more time. They have to also describe, just like in a FAR Part 15 procurement, significant factors and sub-factors, for example, technical approach, past performance, corporate experience, scheduling, preventative maintenance, things like that, including cost or price and how they're gonna evaluate cost or price that the agency expects to consider when they're conducting their own evaluation, including relative importance. So that could range from, lowest price technically acceptable to best value. And, under best value, you would see here all the non-price factors ranked. They could all be equally ranked. They could be one is most important. They could be, descending order of importance. It's critical when you're reviewing to, review the evaluation methods, not just the requirements, so that will give you a clue as to what the government's going to focus on or what's most important. And then, so yeah, that's the next factor. Got ahead of myself, but yeah, so they're gonna tell you in the solicitation, or they should at least, the importance of all the factors and how they're gonna evaluate those factors. And then this is critical, for orders over 5.5 million, they're supposed to provide you a post-award debriefing. Again, this is, if it's under 10 million, you can get the post-award debriefing, which will essentially be a learning opportunity. But if it's under 10 million for a civilian agency, you're not going to be able to protest it. And if it's under 25 million for DoD, you're not going to be able to protest it. So it's important to keep that in mind. But the other key consideration here is that, and I'll talk more about this at the end of the presentation, is under FAR Part 16.505, if the order is worth more than 5.5 million, the debriefing is technically considered required. And I emphasize required because that's important for bringing protests at GAO, which again, I'll discuss later. Another key thing, and this is not on the slides, but Christine and I were talking about it when we were preparing for this, is there is an ongoing battle between government contractors and the government. There is a split between GAO and the courts concerning SBA's rule of two in FAR Part 19, which essentially provides that if 2 or more small businesses can provide the government the services depending on the value of the contract. That contract should be set aside for small businesses. Now, GAO for multiple award contracts has said that the rule of 2 essentially is discretionary at the task order level. That means once the IDIQ is established and they've gone through the analysis of whether small businesses can do it or large businesses or a combination, once they get to the task order level, they do not need to comply with the rule of 2 unless the contract explicitly states that. So for small businesses, this means that they are subject to the whims of the contracting officer, and the rule of 2 just is not going to apply. It's established at the IDIQ level. GAO says you can't protest about this. They're not going to side with you. Now, recently, the Court of Federal Claims, in a decision called Tolliver, and I believe this came out late last year, an agency attempted to cancel a procurement, a small business procurement, and move the work over to a IDIQ contract, a GWAC, government-wide acquisition contract. So they cancel a solicitation and they try to move their requirement over to a large business contract. And the contractor protested this at the court, and the judge held that the government failed to comply with the rule of 2 because they just didn't do the rule of 2 when deciding to place it under the IDIQ vehicle. So that's an important holding for small business contractors because it creates a ruling that small businesses can use to get government agencies scared that failure to follow the rule of 2 at the IDIQ level based on Tolliver could open them up to protests. Now, it's not as easy and shut as that. It's a single case from a trial level judge, and a lot of agencies are still going to go by the FAR, which leaves discretion for multiple award contracts. And it's important to note that our firm has been fighting about this both at GAO and at the court, and DOJ, who represents the government agencies at the court, despises the Tolliver decision, and they are looking for a reason to get it either distinguished by a different judge or overturned at the federal circuit. But I wanted to raise that as the government agencies tend to not like having to comply with small business regulations, including the rule of 2, as there's a general trend towards going towards these, what they're called best-in-class government contracts, and there are these huge GWACs that the government turns to when they're looking to procure supplies and services, and they have trended toward large businesses, the Booz Allens of the world. So I wanted to make you all aware of that. It's certainly a developing issue, and certain to see over the next couple of years what happens with the rule of 2, especially now that the Tolliver decision is in hand, and DOJ wants to get rid of it. Christine, did you want to add anything there?
I think you covered it all. It is important that, the rule of 2 really does help small businesses, and the agencies in GAO are kind of going towards almost eviscerating it and making it unneeded by letting the agencies go to these best-in-class vehicles. So it's important to keep an eye out for what could be happening because this could have a huge impact on small businesses.
Thanks. So with that, I'm going to move on from IDIQ ordering procedures and getting contracts to probably a little bit more somber area of the law that contractors don't enjoy being in. This is a tough area. but it's mandatory disclosure rule. This is an area of the law that essentially, if your company, whether it's you or a rogue employee, or someone in the company kind of messes up, whether it's intentionally or unintentionally. I say intentionally for criminal law, where there's fraud, conflict of interest, bribery, gratuities, those types of violations, or I say unintentionally, though it could be intentionally as well, for violation of the Civil False Claims Act, which is essentially assertions to the government for monies owed, which you're asserting falsely, either knowingly or recklessly. These types of violations of the law trigger what's known as the mandatory disclosure rule, which appears at FAR 52.203-13. And it provides that the contractor shall timely disclose in writing to the agency's Office of the Inspector General, with a copy to the contracting officer whenever, in connection with the award, performance, closeout of a contract or subcontract, if the contractor has credible evidence that a principal, employee, agent, or subcontractor of the contractor has committed a specified criminal violation under Title 18 or the False Claims Act. Under this, so what happens after you submit? This can open up government contractors to suspension and debarment proceedings. I've actually handled and submitted quite a few mandatory disclosures at this point. Sometimes you submit and the OIG sits on it and you might not hear anything for years. Sometimes you hear back immediately, not from OIG, but from a suspension and debarment official, which is a whole different proceeding under the FAR, where you can essentially be suspended from the government contracts practice. It's very serious. It could be, it could apply to an individual, or it could apply to an entire company. As government contractors, I know you all know that if your company's bread and butter is all government contracts and you're debarred, that can destroy your company and the livelihoods of your employees. So, this is a very sensitive area of the law of our practice. So, I'm going to talk through today some tips and how we approach these things, and how you should, or what you should keep in mind as you continue to run your business. And if you have the unfortunate event of discovering an event that might trigger a mandatory disclosure. The important part, so as to not scare all of you, when there's a suspension and debarment proceeding, debarment is a very drastic measure. It's not favored under the case law, and that's so long as you can make the case that the company itself is presently responsible. So yes, something horrible might have happened, but if you can show that you fired the employee that did the wrong action, you've updated your policies, you've done training, you've put in procedures that will prevent this issue and other issues. If you can show present responsibility and that you're ready and responsible to keep performing, that goes a long way to avoiding a suspension or a debarment if you're willing to work with the government. So there are ways, if this happens, to stem off potential harm to the company. So when are you required to disclose? It's a knowing failure by a principal to timely disclose. So what do we mean by knowing? It must be actual knowledge, not recklessness or indifference. The FAR Council, when they've weighed in, they rejected or should have known as just too far beyond the pale for when a mandatory disclosure is required. And then critically, the FAR also recognizes that until the contractor has determined the evidence to be credible, there is no knowledge. So what does that mean? it means there is built-in time for your company to conduct an investigation of the matter. So when I say investigation, I mean both internal investigation and you want to have you want outside counsel involved so that they can run their own investigation. So for example, I would, or Christine and I would conduct witness interviews. We would review documents. We would look through your policies. We would potentially suggest remedial measures for your company during the pendency of the investigation to start buffering against any suspension and debarment proceedings that could be instituted. But we would then also provide a written memorandum of what we think the failure was, or what could trigger whether there is a mandatory disclosure requirement or not. I say outside counsel because if you have inside counsel or in-house counsel and they conduct the investigation, that is likely not going to be protected by attorney-client privilege. None of those communications are. So the government, if it did find out about something and there was no mandatory disclosure and they start going through your records, those are all going to be fair game for an investigation and for litigation brought by DOJ. Whereas if your attorneys, your outside attorneys conduct the investigation and give you attorney-client work product, that's going to be protected. And as your attorneys, we don't tell you to make a disclosure. We tell you the requirements to make a disclosure. So, you get that memo. It's a judgment call on the company, but it'll at least be protected from discovery. So that's what I mean by knowing. It's just taking the time to run the investigation and figure out what happened. More often than not, you're gonna want to tell the government if you have credible evidence, because again, it's presently responsible contractors that maintain status as a government contractor. And you don't want it to be found out later that you didn't disclose, because that in and of itself, we'll talk about, can lead to issues. So knowing failure by a principal. Last bullet's important. Principal, it's broadly construed. So it can mean officer, director, owner, partner, persons having primary management or supervisory responsibilities within a business entity. It doesn't go below that, but it's not safe to assume that someone higher up is not a principal just because they don't have an ownership interest, or that they're not, a CFO or a CEO. The government's going to read it pretty broadly if they have a primary role within the government. So knowing failure by a principal, you have to timely disclose it. So it's not just, oh, I've discovered something, I'll let it sit for a little while, I'll figure it out when I figure it out. No, once you know about something, it triggers the requirement. But again, that's on a case-by-case basis. So the FAR Council, who drafts and promulgates the federal acquisition regulation, they've rejected these suggestions of 30, 60, and 90 days. But really it comes down to how the government, meaning the OIG's office for the particular agency, is going to interpret timely. So, you want to get outside counsel involved immediately. You want to take remedial measures immediately. You want to conduct an investigation within a reasonable time frame. But, like the second bullet says, there is some delay in disclosure so that you can conduct these investigations, but they can't go on and on. And it will have to be disclosed eventually if there's a knowing failure. And then timeliness is then measured from when you knew. So if you don't timely disclose, this can be a reason to find that you are not presently responsible as a government contractor if they were to institute suspension and debarment. So it behooves you to do things efficiently and then to provide notice to the government. But if they find out that you've known for years and you're just coming forward, that is going to be a much steeper hill to climb than if you found out and told them within months instead. So that's what we mean by timely disclosure. And then it's credible evidence. And this is part of what's going to go through or determined in the investigation. And this is where we're going to figure out, is it a criminal act under Title 18? Is it a violation of the False Claims Act, which is, it can be a pretty complicated analysis depending on the jurisdiction, given that each state's jurisdiction has different rules on this. And then the other major one that we typically see are significant overpayments on a contract. So, first one, again, is federal crimes involving fraud, conflict of interest, bribery, or gratuity violations. You can go onto DOJ's website and look through some of these. There was one recently out of San Diego where the government contractor was paying a government employee to, push contracts to the contractor. The government employee was taking, a large salary from this government contractor, bribes, the whole gambit that you would see in these typical types of scenarios. And those are things that if you found out as a principal that some of your lower officials were doing that, you'd have to disclose that. And you'd probably be subject to, potentially litigation with DOJ and definitely suspension and debarment procedures. But the other element of mandatory disclosure involves False Claims Act. So this could be, backdoor violations. Disclosure could be an admission of liability. And this is where you want attorneys involved because you want these disclosures to be very carefully worded. They can be forthright, but they're also gonna likely admit liability. They're gonna be on the record with the US government. Once they go out, they're not gonna have attorney-client privilege. And you wanna put it in a position where you're gonna eventually have to defend yourself in litigation. So it's, we often recommend that the attorneys help with drafting the disclosures, even though it is the disclosure coming from the company. Another key consideration when you're conducting investigations or when employees have access to certain files is that you want trustworthy employees as a practical matter, because not only can the government come after you, but your employees can come after you as qui tam relators. And if they file suit, they can continue that suit even if the United States government does not intervene. If the government doesn't intervene, it takes the wind out of the sails a little bit, but you're still subject to a qui tam action in federal court, which can be costly. So there's criminal violations, False Claims Act, and then the last one is significant overpayments on a contract. This is more common than you would think. It can happen as a simple slip in an Excel sheet where you add an extra rate or an extra fee, or something occurs and then it happens and you don't correct it moving forward. So there's overpayments, and it happens. Mistakes happen, but the mandatory disclosure is not typically going to be required for a routine contract payment issue, unless there's just a really reckless disregard for how you're invoicing the government. But like routine issues, it's not going to trigger mandatory disclosure. But again, it's fact intensive. You'd want probably attorneys and accountants taking a look to figure out what happened. If you can't figure it out very quickly internally, sometimes the government will ask for its own audit from DCAA, or you can ask for an audit for potentially a subcontractor if you think that there are issues with the subcontractor going on that you're not privy to their data, which is fairly common in the government contracting space. But as a prime contractor, it is your responsibility not to overbill the government. So you'd want to build into your contracts or your subcontracts the ability to audit subcontractors. It might seem like a strange requirement when you're starting off on a new business venture with a a large company, or maybe even just a company slightly larger than your own, and it's good business relations, but you just don't know what the future holds. So it's important to keep in mind that mistakes happen, and sometimes it's not a mistake. Sometimes someone is trying to overbuild the government, and as the prime, that hammer is going to fall on you. Not saying you can't go after the sub for that, but the government's going to come to you for remuneration. So just important to keep these things in mind. So that is the mandatory disclosure rule in a nutshell. Again, this is an area that's uncomfortable for many people, but you can get through it if you do it right, and especially if you get attorneys involved towards the beginning, rather than waiting and sitting on it, because they are going to be able to guide you through the process and make sure you at least avoid missteps. So with that, I'm going to turn it over to Christine to talk about some employee compensation reporting issues.
So this is another reporting requirement. It kind of came about a bit ago because there was concern that executives were making too much, and some people wanted to be able to see if they're making a lot off of government contracts. But really, this is not open for everyone to see. Your neighbor can't see it, someone else can't see it. It is just reporting that you need to do if you are the prime contractor or the first tier subcontractor. It's also important to note, which is on the next slides, that there's really only one exception here. And if the executive's income is less than 300,000, but if not, then the top 5 executives, so it could be officers, managing partners, or other employees in management positions, need to report their compensation under FAR 52.204-10. So in determining total compensation, you have to look at salary and bonuses, awards of stock, stock options, and stock appreciation rights. To do this, you use the dollar amount recognized for financial statement reporting purposes with respect to the fiscal year in accordance with the Financial Accounting Standards Board's accounting standards codification. The next thing that you also have to incorporate when determining total compensation is earnings for services under non-equity incentive plans. However, this doesn't include anything like group life health, hospitalization or medical reimbursement plans, anything that most employees are getting at the company. So like a salaried employee is getting, you don't have to add that in, but you do have to add stuff in that only applies to executives. Like if an executive is getting something that a regular salary employee is not, then that does count for total compensation. It also includes a change in pension value. This is the change in present value of defined benefits and actuarial pension plans. Fifth, you have to incorporate above market earnings on deferred compensation, which is not tax qualified in total compensation. And then finally, other compensations if the aggregate value of all such other compensation, so severance, termination payments, value of life insurance paid on behalf of the employee, for the executive exceeds $10,000. So if this total compensation exceeds $10,000, for other compensation, it also needs to be calculated into the total compensation. Again, this only applies to there we go. The prime, the first tier subcontractor. So the prime contractor reporting, it's the preceding fiscal year. The contractor received 80% or more of its annual gross revenue from federal contracts and subcontracts, loans, grants, and subgrants, cooperative agreements, and other forms of federal financial assistance, and 25 million or more in annual gross revenues from federal contracts and subcontracts, loans, grants, subgrants, cooperative agreements, and other forms of federal financial assistance. And the public does not have access to information about the compensation of executives through the periodic reports filed under the various subsections of the Securities and Exchange Act or the Internal Revenue Code. Again, the only exemption that's a true exemption is if the executive's total compensation, as we calculated on the previous slide, is less than $300,000. Subcontractor reporting is similar in the subcontractor's preceding fiscal year if the subcontractor received 80% more of its annual gross revenues from federal contracts and subcontracts, loans, grants, and subgrants, cooperative agreements, and other forms of federal financial assistance, and $25 million or more in annual gross revenues from the same. And the public does not have access to the information under the Securities Exchange Act of 1934 or the Internal Revenue Code of 1986. Then you also have to report the total compensation of the top 5 executives unless the executive makes $300,000 or less. And Tim is going to go ahead and take over performance of work requirements.
Okay, hi everyone. Before I launch into performance work requirements, I just wanted to flag that I was incorrect earlier when I said there are the 8A and the all small mentor protege programs. There's just one program now. Thank you, Mr. Nielsen, for the email. I appreciate that. They were recently merged, so there is now just one SBA all small program. So moving on to performance of work requirements. This is also known as the limitations on subcontracting, which appears in SBA's regulation at 13 CFR 125.6. This is an area that the Department of Justice is really focused on, as they think it is essentially rampant with fraud, where small business contractors are being used by large businesses as essentially just pass-through entities, where the large business is the one basically pulling all the strings and doing all the work. So this is an area to be careful in because it's tricky and takes a lot of reporting, and it's not an easy thing to keep track of given the various types of not just contracts and procurements, but the delivery methods. So if you have one, if it's an IDIQ contract or just a standard contract for supplies and services. But depending on the contract you have, and again, it's services or supplies based on the NAICS code, you basically just take, for services, the total cost of the contract, you figure out what it's for, and then you subtract all supplies. I'm sorry, you include materials, take the total contract, the amount of services that you have for that contract, you have to perform as the prime contractor a certain amount of that contract to comply with the limitations on subcontracting. In other words, you cannot win a prime contract and then just subcontract all the work out to a large contractor. These programs, SBA would posit, are in existence for small businesses, not just to win them, but to perform them, at least for certain amounts. So the regulation itself lays out specific types of percentages that you have to meet depending on the type of contract. And then you have to measure that based on the, quote, period of performance. And the period varies based on the contract. It could be 1 year, it could be 6 months, it could be 6 months and then 4 years. You have to figure out the period of performance, and then for each period, you have to meet that threshold. So if it's construction, you have to do 15% as that small business. So it can be difficult to keep track of that when you have multiple task orders going on, but you're still required to do it. It's a material requirement of your contract, and you can get in trouble, including with DOJ, if you don't do it. So we get a lot of questions on this from clients, and a lot of questions about how to figure things out. So please, contact us, contact your attorneys if you're having issues with figuring out the limitations on subcontracting, figuring out how to keep it in line. But here's some free legal advice. When you're subcontracting, you can delineate based on the limitations of subcontracting how much work you're giving your subcontractor, and you can just set it to an amount that you feel comfortable has a healthy buffer that you're not going to violate this rule. So you can just keep 90% of the work, or if it's construction, you can keep 50% of the work and the other 50 will go, and then you're going to hit that 15% minimum. Because these again are just minimums. They're what you have to hit to not violate it. But your subcontract, if you want to keep the work and do it yourself, feel free. But as a practical matter, there aren't many small businesses that can do an entire contract by itself. Subcontracting is very common. This is just something you want to keep in mind when you're subcontracting and working out agreements. Now, all that said, there is an exception to this, which involves similarly situated contractors. So if you're an 8A, you can essentially, under SBA's rule, subcontract out essentially as much work as you want to that 8A subcontractor, if you're both 8As, or if you're both SDVOSBs, or both small, or both hub zones. So this is a relatively recent change. And if you are an 8A small business contractor and you have one small business subcontractor, you could ostensibly subcontract out a large, if not all, of the work. Not saying that's what you want to do, but there are ways in the rules to comply with this without doing all the work yourself. But there are also rules that, as you go down different subcontract levels, so first tier, second tier, different rules apply. And for similarly situated contractors, the ostensible subcontractor rule is waived. That's in a nutshell where the subcontractor is, you're overly reliant on that subcontractor to perform to the point where that subcontractor is essentially performing the contract, and you're affiliated, or the OHA SBA would deem you affiliated. That is waived for similarly situated subcontractors. The next area that we're going to talk about, so this is OCIs, and then we're going to finish up a debriefing, so just hang in there with me. OCIs are another hot topic, and this is, I think, and I think many would agree with me, an area that is incredibly complicated for all involved parties, whether it's the government contractor or the contracting office. OCIs are tricky and fact intensive, and they can be difficult to determine. And frankly, a lot of people struggle with OCIs, but I do think it's important to read out the definition to give a base understanding. So an OCI arises, an organizational conflict of interest arises when, because of other relationships or circumstances, a contractor may be unable or potentially unable to render impartial advice or assistance to the government. The contractor's objectivity in performing the contract work is or might be impaired, and or the contractor would have an unfair competitive advantage. That is a broad definition provided in the FAR. It could, as you can probably tell just by reading that, it's not specific, and numerous situations could apply. So that said, there are generally 3 types of OCIs that we're going to discuss today: unequal access to information, biased ground rules, and impaired objectivity. So unequal access, I'm going to there's a slide on each of these, but I'll give you a quick rundown. Unequal access to information is basically when you, as a government contractor on your contract, get access to non-public information that could give your bid and proposal team an advantage on a different procurement. A biased ground rules is where your work as a government contractor on a contract allows you to, quote, set the ground rules for a follow-on or another procurement. So, for example, you are helping a government agency produce a solicitation, and then you yourself go bid on that solicitation. That's that you've set the ground rules for. You've been intimately involved with that contract. That's where a biased ground rules OCI would come up. Impaired objectivity. This is where you, for example, under one contract, produce a report, and then on a different contract that you're on, would be reviewing that report and assessing it. You would essentially be reviewing your own work, which is inherently a conflict. That, in a nutshell, is what impaired objectivity is. So those are the three basic groupings. Those are what you would be trying to mitigate or avoid prior to award or even during performance. We'll get to that in a minute. But like I said, it is a complex analysis that the government contractor and the government must go through to figure out, is there an OCI? Is there an appearance of an OCI? And under either scenario, has it been effectively mitigated or avoided? This typically involves a deep dive into your current contract and what you're required to do under that contract and what you actually do under that contract, and then figuring out whether it creates a conflict on a future procurement. So there's a lot of document review, and then assessing those documents and those various requirements against your current policies in place and how you've behaved or what procedures you put in place under the contract. So it is incredibly fact specific, and they're dynamic. It forces you to put your thinking hat on to figure out, okay, well, I didn't do that, but is there an appearance that you could have? Is often the question I pose back. So you have to think not just is there an actual conflict, is there an appearance of a conflict? That is enough to raise an OCI concern, which you'd want to put a mitigation plan in place, or just a plan to make sure that these things are avoided. Because yes, OCIs occur, but they can be mitigated, they can be neutralized, and they can be avoided prior to it arising if you have the right procedures in place, the right policies, and the wherewithal to even know that one was coming your way to begin with. So again, complicated, but they can be handled appropriately. So again, unequal access to information. This, of the three types of OCIs that I've mentioned, this is by far the easiest one to mitigate and to avoid. And you don't need to get the government involved typically. It can be dealt with in-house. You can alert the government if they're asking about OCI issues in the procurement. But essentially it comes down to limiting access to competitively useful information. So for example, a lot of government contractors, at least back in the old days before we were all teleworking, you'd have the business development team at corporate headquarters doing the day-to-day for the company, and you'd have your employees working at an agency facility or maybe going back and forth, but they're in the nitty-gritty of the government contract itself. If you put in procedures that limit what information is shared between those various groups of people, and you put in firewalls, or if you have those personnel working on the government contract in separate facilities, you have them trained to know about OCIs, they know to sign NDAs, and they have them executed, they know not to release information and don't do it. That is typically what you need to do to mitigate or avoid an unequal access to information, because again, it comes down to, are the people drafting this bid or proposal for the company privy to this information that gives you a competitive advantage? Or is there an appearance of that? So if you can include with your proposal a statement or some type of information showing that your employees working on the government contract that could give rise to the OCI have been essentially firewalled off and haven't shared the information, that typically does it. That will mitigate this type of OCI. Next one, bias ground rules. Again, this is where you have in your performance of the contract laid the ground rules for another contract. So you've drafted this solicitation, you've drafted the specifications of a different solicitation. You essentially have a leg up because you know what's in that procurement before anyone else does. And that's potentially a bias ground rules conflict. And it's incredibly hard to mitigate. It can be hard sometimes to determine if it even exists. But it typically involves government involvement because the firewalls aren't necessarily effective here, given that it's going to apply to the entire company. And then you're generally not going to be able to use affiliated divisions or entities because, again, it's going to be a company AI. So you're going to, if the government's willing to play ball with you and they don't just disqualify you outright, it's going to require government participation to mitigate the OCI. And typically that comes in the form of recusal. So you would find which areas of the procurement have these OCIs associated with them. You'd recuse yourself from it and then bring in a subcontractor to take care of that. And then you also have the employee firewalls, NTAs, in cooperation, but it does require a lot more effort than just coming in and performing a contract. And it's going to take a lot of government involvement and communication, and sometimes it still can't be mitigated. I should also add here before I go on to the third one, there is no limit to the number and types of OCIs that can apply to a situation. You theoretically could have all three types of OCIs, and there could be multiple kinds of these OCIs. There could be different categories of information that have given you a competitive advantage. So all of them would have to be addressed, not just one or the other. All three of them could theoretically apply. Next is comparative objectivity. This one is extremely difficult to mitigate. Some would say impossible to mitigate. And it's where you are essentially evaluating your own work. Or if it's a conflict based on an affiliation with an organization, with an economic interest. But generally, unlike the other two, well, unlike unequal access OCIs, I should say, firewalls are not going to be effective. It's going to apply again to the entire corporate entity, including subsidiaries, affiliates, etc. And any knowledge or potential knowledge of the entity being evaluated. So this could be, your teaming partner, your sub, is the one that you're going to be evaluating on a different contract. This could also trigger an impaired objectivity. So it's just incredibly difficult to mitigate. It's more likely to trigger an exclusion from the competition or the procurement. So it's good to know beforehand and then talk to the government about it because they might be willing to work with you to put procedures in place. Or if worse comes to worse, and this is theoretically an option, the government can waive the OCI. But otherwise, you're going to have to work with them to get supervision and control and come up with some objective criteria to limit the scope of the OCI. And it can be very difficult. Now, for all three types of OCIs, it's not just the government contractor that's doing the analysis, it's also the government. The contracting officer is responsible under the FAR for determining whether there's an OCI or not. So if you don't provide this information, and then later someone down the line protests, and you've never provided this information, the contracting officer has never even looked at it, GAO or the court would likely find that there is an OCI issue and sustain the protest. So we tell clients typically, you want to share information with the government with this, even if there is the potential that they could find an OCI exists, because you could mitigate it. You could put a plan together and proceed and get procedures in place to avoid it. But at least that way the government has the ability to review it and make their own determination as to whether there's an OCI, which is much more likely to survive a protest, given that there's a reasonableness standard, and the GAO and the court generally defer to the agency's reasoning. It doesn't always defer, because sometimes it's just too flawed, but if the government has put forward a reasonable analysis, it typically is going to be upheld. So it's important for the government to know about these issues, especially if they've asked about it in the procurement. So that's OCIs. So now we can move into debriefings, which are governed by FAR 15.506 for civilian agencies, and the DoD has its own enhanced post-award debriefings for FAR Part 15 procurements. This is a relatively new thing for the DoD, and it only applies to FAR Part 15 again. It wouldn't be, FAR Part 12 or FAR Part 8. Sometimes you can get them to apply it to a task order under FAR Part 16, because there is a reference in FAR Part 16 that quotes back to FAR Part 15. But essentially an enhanced debriefing with DoD is if you request a timely debriefing in writing within 3 days, it triggers the enhanced debriefing requirements, where you get to essentially submit questions to DoD within a set amount of time, and then DoD has to answer your questions in writing after a certain amount of time. This is important, and it is critically important because of what I mean by, quote, a required debriefing. Depending on which FAR part you're under, you might not get a required debriefing. For example, we'll talk in a second about FAR Part 8 and FAR Part 12. But under FAR Part 15.506, you cannot bring your GAO protest until your required debriefing concludes. So it's important to ask for your required debriefing timely, so within 3 days, in writing, and then to have your debriefing with the DoD or the civilian agency. And then within 5 days of that, you get to file at GAO and get an automatic stay of performance. So what's critical for government contractors, if you do want to protest after receiving notice of an unsuccessful offer, is immediately requesting and writing a debriefing and getting your protest counsel involved so that they can help you prepare debriefing questions and then get started on a potential protest. Because once the debriefing is closed, if you want to get that stay of performance, which is critical to exert pressure on the agency, you have to do it within 5 days of the debriefing. Now for DoD, you of course get more built-in time because it's enhanced. So it's also critical, it's even more critical there to get it, the request in timely, because otherwise, under both scenarios, if you don't request the debriefing in time, it's then no longer required, and then it defaults to 10 days from the date of award. And you might not get information which you would have otherwise gotten during a debriefing. So, main takeaway, whether it's pre-award or post-award, is you have to ask for a debriefing within 3 days under FAR Part 15 procurements, because the government has to give you a debriefing. Excuse me, one sec. So after you've asked that, you get your debriefing, and we'll talk about that in a moment. But so for FAR Part 15, you can get a pre-award notification that you've been excluded from the competitive range, or for procurements that are set aside. Those pre-award debriefings are required, and you should request a debriefing, and they have to give it to you. Some contractors defer their pre-award debrief and then try to have a post-award debriefing. This is a pitfall, it's a trap, because if you defer your pre-award debriefing, it is no longer considered required, but your time to protest at GAO is not affected by that. Meaning you have to raise your protest grounds within the same timeframes, otherwise they're waived when you go to raise them when you found out in your post-award debriefing. So, like I was saying, you only get them, the required debriefings, in certain procurements, FAR Part 15 and FAR Part 16. You do not get them under FAR Part 8 or FAR Part 12. Under FAR Part 8, even though government contracting officers often call it a debriefing, what they actually mean to say is a brief explanation of award. And it's not what you would typically get in a debriefing. It's just, as it's titled, a brief explanation where they have to provide a little bit of information. Often I've seen them a page with basically no information. But the clock is running for you to submit your protest at GAO. It's 10 days because it's not required like it is in FAR Part 15. So the clock just starts and you have to file within 10 days. If you do file within 10 days, you still get the stay. But there's probably a little less time and a little less information. So how do you request a debriefing? Like I said, you do it within 3 days. You do it in writing so that there's no issue with the record when you are filing at the GAO. Typically, the debriefing will happen as soon as practicable. The government, for pre-award at least, will tend to push them. It is your duty as a government contractor to zealously advocate for yourself and your protest grounds. Otherwise, they can be dismissed. So we tell clients, if the agency is not responding, keep on them, call them, email them, build a record to show GAO you are trying to get your post-award debriefing, or I'm sorry, your pre-award. Like I said in the last slide, you can opt for a post-award protest, but you will lose any protest grounds that you could have raised pre-award. So it's often never worth putting it off, even if the agency suggests it. Agency counsel and the contracting officials know full well that you're going to be able to, or not going to be able to bring these protest grounds if you defer it. So that is a pitfall that you should avoid. Post-award, same. You should request in writing within 3 days after notice of the contract award. The debriefing is supposed to occur within 5 days of the request, but sometimes it can get pushed further. You can have, so you know, a written debriefing or a telephonic debriefing. Preferably, you'd want things in writing from the government, but it's not always the case. Often our job as attorneys is to get involved and to start framing questions for you to submit to the government. So it's typically a good idea to get protest counsel involved very quickly. You know, for example, if you've had your debriefing, the clock is ticking, and you have to get a stay within 5 days, but you tell your lawyers the day before protest is due, they might tell you, sorry, we don't have bandwidth, we can't help you. So it is just critical to get counsel involved if you think there's a chance you're going to protest. So what exactly does an agency have to tell you in a debriefing? Again, DOD is going to give you a little bit more information under their enhanced debriefing, but otherwise it's spelled out in the FAR for pre-award and post-award. For pre-award, It's going to be evaluation of significant elements of your proposal, why they eliminated you from the competition, and reasonable responses to your relevant questions. I always say shoot for the moon, ask whatever you want. The agency will answer what it wants to answer, whether it's pre-award or post-award. Unfortunately, if they give you a bunch of bad answers or just no answers, frankly, GAO does not get involved in that process, nor does the court. It's difficult to enforce it. However, once you're at GAO, the attorneys will get access to the full record. So anything that they don't answer during a debriefing, so long as you can get your foot in the door and your protest grounds are timely, your attorneys are going to be able to access it. So don't sweat too much if they're not giving you answers, but be persistent and try to get answers because it will help frame the protests. For post-award, they're going to talk to you about significant weaknesses or deficiencies, overall evaluated costs, and technical rating of you and the awardee, past performance information. If there was a ranking, they'll give you that. They should give you a summary of rationale for the award. And again, reasonable responses to relevant questions about you. They're not going to dig too deeply into the awardee or other offerors. What sometimes you'll see from DoD, they'll just give you excerpts from the agency report itself. DoD is tending to provide more information because it tends to honestly stop people from protesting when they get a full record. The attorneys will be able to say or give a more reasonable assessment of the odds of winning, which are low to begin with. But if you have more of the record at the debriefing stage, we can tell you whether there are just so many errors in it that we think a protest is worth it or not. But other agencies don't tend to give as much information, especially if it's under FAR Part 8. But yeah, those are required debriefings. So, I mean, what's really critical, the main takeaway for debriefings is figure out which FAR part you're under and whether the debriefing is required. If it's under FAR Part 15, it's going to be required, and as long as you've requested it timely. If it's FAR Part 16 and the task order is worth more than 5.5 million, you are entitled to a post-award debriefing. You are not entitled to a pre-award debriefing. Otherwise, for the different FAR parts, it's not going to be a debriefing, or there might not be any. Depending on the FAR part, you got to figure it out. But FAR Part 36, for example, has its own debriefing requirements for architecture and engineer contracts. FAR Part 8, brief explanation of award. So that is debriefings. And I suppose now we can go into the questions. We have some time for questions. We can go through the box and try to answer to the best of our abilities. Otherwise, we might have to follow up with you later via email. So I will just go down from the beginning. Have the slides been posted on the website? They will be posted after the presentation. Will certs be available for attendance? Edna, do you know the answer to that question? I do not.
I've already answered most of them, so I think you can start with the one that was asked by Miriam Hamilton.
Okay.
Yeah.
Can the supplier keep small designation if they were small at the time of proposal to the government and certified at that time? Then at the time of the award, the supplier merged with a large business. I mean, I think that there is some factual scenario where that's possible, but you are going to be certifying shortly thereafter because you've merged with a large business. So you're still going to have to recertify at some point. But I guess theoretically, yes, at the time of award, it could be a small business contract, but given you're being bought out by a large, given the FAR regulations, you'll have to recertify. If you're a subcontractor, if you assert data rights, are you asserting it to the prime or directly to the government? So that's a very good question. And you typically, as a subcontractor, would want to negotiate a license with the prime contractor and an end user license agreement, making sure that all of your rights are being protected when the prime submits its proposal, which would then be submitted directly to the government. In data rights, are there distinct terms from distinguishing between the data developed in the programming code? As opposed to, yes, there are different types of data, technical, commercial, non-commercial, and the rights that associate with each of those types of data, you figure out by going to the appropriate FAR clause. If an SDVOSB started the process for an MPP agreement, I assume you mean mentor-protege agreement, but the deal was not executed, how would the SDVOSB go about clawing back the request? Generally, how difficult would that effort be? I'm not sure. I imagine you could simply withdraw the request from SBA, if that's what you mean, the mentor-protege. Christine, do you happen to know?
No, sorry, my panel just popped up with questions, so no, I do not know.
Oh, okay, no problem. Yeah, I imagine it would be submitting a request to get that withdrawn. How long can post-employment restrictions be required enforced? I.e., how long would we need to keep track of ex-employees? This really depends on the type of employee and which FAR clause would apply. So I cannot give a specific answer to this. Christine, is that also your understanding?
Yes, it is. My understanding, it's very fact specific.
Okay, this is great so far. Thanks so much. Thank you. Did something happen to the sound? I hope that got fixed. Sorry, Betsy, if it didn't, but I think they'll also be circulating a audio of this as well, or I think it'll be eventually put on YouTube. Next question, if an agency puts out an RFQ for a specific item not made in the US, would we still need to get a waiver, or is the solicitation itself a waiver? I think to be on the safe side, you'd still want to get a waiver. Are you aware of any FAR clauses which address sole sourcing and maybe a clue as to how to encourage an agency to set you up as a sole source for any given solicitation? Yeah, there are particular clauses that deal with sole source justifications. I think it would just be a matter of communicating with the agency, but this is generally difficult given the extra paperwork it requires. But it has happened, and government contractors are often sole sourced for their products. Can you repeat the size limits for protests and debriefs mentioned in IDIQ ordering procedures? Yes, to go to GAO for a task order procurement, for a civilian agency, it's 10 million. For DOD, it is 25 million. Could you just list a couple little example of these kinds of things we'd need to disclose? So this, I think, was mandatory disclosure. So if your employee submitted fraudulent documentation to the agency, that's one example. If you submitted false certifications to the agency, if a government falsely certified something on an invoice to the agency, if one of your employees bribed a government employee. Oh, sorry, you also said, never mind, thank you. Okay, so those are a few examples. During a mandatory disclosure situation, is there a reason and or method to inform the government that you are initiating an investigation, but you have been unable to establish a violation at this point, or just wait until the investigation return results? So this can occur if you are working in a complicated contract matter where outside counsel is involved. For example, sometimes in the claim, you'd be submitting a government claim, and maybe in review of that claim, the government has spotted issues that you then tell them you're running an investigation. Otherwise, you would probably sit tight. It really depends on a number of factors, such as how serious the initial results are from just a preliminary investigation, the government and the agency involved, etc. But it really is a situation by situation basis. For overbilling the government, is there a maximum amount of profit that is acceptable? If the market bears your rates, but your indirect costs are very low, are you overbilling if your profit rate is really high? I do believe that there are set rates that you cannot exceed for certain types of contracts, like cost plus fixed fee contracts. But this would depend on each procurement and would be a detailed analysis of what is fair and reasonable for that procurement itself. And I'll let Christine weigh in if she has any, maybe a more definitive answer there.
No, sorry, I do not.
Slide 36 is the exemption for the executive or the company.
I can answer this one though.
Okay.
Yeah, so this is for the exemption. There is not an exemption. The only true exemption is really that $300,000 cap. So you do need to report the compensation for the executive of the company if they're within the top 5 employees.
Got it. Why wouldn't you always request an enhanced debriefing when it is available to you? Correct. I always recommend you request the enhanced debriefing when it's a DoD procurement. It gives you extra time, allows you to ask more questions, and is generally beneficial. I see no reason why you wouldn't move forward with an enhanced debriefing. Sometimes the contractor forgets to ask for the debriefing in a timely manner, and then you wouldn't get the enhanced debriefing. Another thing to keep in mind that I didn't mention is that the clock starts ticking as soon as you open the email from the government, even if it's after business hours. So it's not always a good thing to open your emails at midnight or 11:59. The case law is a little squishy on this point, but if you get it on Wednesday at 9 p.m., you know, the 3 days has technically started as of 9 o'clock that night. Even though the government gets away with saying, well, we close at 4:30, so anything that comes after is the next day. That does not necessarily apply to government contractors. Are Brooks Act procurements require debriefings? I do not know off the top of my head, but Jay, I can look into that and get back to you. Just taking a note on that. In the past, we seldom were notified that we were excluded from the competition. Can we request a debriefing at any time after the submission date has passed? So that's an interesting question. I would request, yeah, I mean, I would definitely ask the government for updates. That's absolutely fine. And if you didn't get notice, then I would argue that the timing requirements have not been triggered yet. So you could still ask for a debriefing. Unfortunately, given GAO case law, if they screwed up and made award and contract performance has started, the best you might get away with is filing a protest and then recovering potentially procurement fees, maybe proposal fees. So I mean, I have seen it happen where unfortunately the government never notified the person, and it ended up they couldn't really recover anything given the how bad the mistake was. Okay. Where does it say in writing that IDIQ for DoD can't be protested if under 25 million? I don't have the statute in front of me, but it's in Title 10. 1 second, I can find it. It appears at 10 USC section 2304C, subparagraphs E1A, and at 41 USC 4106 FA. Edna, I will let you answer the CPE CLE credit for attendance.
No, this is only for education, so there is no CPE or CLE credit for this presentation, this webinar.
Thanks. And next is follow up to your answer. Do you mean we have to report the top 5 executives' total compensation, even if it is below 300,000? Christine, do you know the answer to that?
I don't think I understand the question. If it's above 300,000, then you have to report. If it's below, you do not.
Got it. And this is a follow-up from Jay. I recall a case from about 4 to 5 years ago that said Brooks Act procurements were not required. I wasn't sure if there has been any change. I disagree with the logic. Yeah, I wouldn't be surprised if GAO has weighed in and said they're not required. I also recall reading a case similar to that, which is what I was going to look into. But it might not be required, given that from what I recall, it might be that because it's not a quote competitive procurement is what's coming to mind, but I will take a look at that and follow up with you. And those are all the, oh wait. Sid, the statutes are 10 USC section 2304C and 41 USC 4106. 10 USC 2304C and 41 USC 4106. How do we nicely remind agencies about the rule of 2 and the cool recent court ruling you referenced? We have done it through letters. You can ask your legal counsel to send letters anonymously on your behalf, which we do all the time. Or if you just want to get out there and get in front of it and you're not afraid to put your name out there, you can send letters or quick emails with a short analysis, nicely reminding them. Or you can tell them over the phone if you've had maybe a teleconference. But yeah, there are multiple ways to alert agencies about these things. So that was the last question. Thank you all for joining. I really appreciate it. We had a lot of fun preparing this and going through all these clauses. So we look forward to hearing from you all in the future. And again, if you have any questions or anything, please feel free to reach out. Our firm has years and years of experience dealing with these clauses and working through regulatory compliance. So thanks again.
Thank you.
Okay, thank you guys. Please make sure everybody to contact us to make an appointment for one-on-one counseling, or if you have any questions. And thank you, Tim and Christine, for today's presentation. Thank you, everybody, for joining us today, and I hope you register for our upcoming webinar. Have a nice day. Thank you, guys.
Bye, everyone.